Hi everybody. I'm going to call this meeting to order. My name is Abno Vickus. I'm the chair for today. Normally I'm not the chair. Our chair is not here, so I'll be acting as chair. Do a quick roll call. To my left is Ben Barry.
Dave Peterson.
Thank you guys for your time tonight. We have an agenda with 2 items on this. Before we get to those items, is there any comments from anyone here that's not related to what's on the agenda? Okay, hearing none. Our next agenda item is the approval of the meeting notes from March 25th, 26th. Oh, Dahlia. Oh, sorry, and Dahlia.
I'm here. Hi. It's okay. Thanks. I'm here. And yes, I approve the notes. I make a motion to approve the notes.
You make a motion for the notes. Did I hear a second?
I second.
All right. All those in favor?
Aye.
Aye.
Hearing none, that passes. All right, so our first item is, okay, this is new for this group, which is the Kensington Tree Arbitration Board. So we've never done this before. It's something that's got added to our plate, so this will be the first time. So everyone be patient and work with us as we work through this new ordinance and making sure we do the best we can to follow it as well. So do we have the homeowners for, or the claim, I guess we start with the claimants? All 3 of you? Do you guys want to come forward, or do you want to stand up so everyone can hear you and walk us through?
I would like to stand up there on their attorney, because I'm having trouble hearing you from back there.
Oh, okay.
So if you don't mind, I'll just stand here. But, and so I represent the tree claimants.
Okay.
And they are all here, and they can answer questions, I can answer questions, but as you know, we submitted a rather detailed packet of information. And at this point, I have nothing to say to add to that in particular. If you have questions, we're here to answer them. And of course, if the tree owners are going to speak, then I will take notes and respond to that if it appears that I should respond to that, if you don't mind.
Okay.
And if you want my clients to testify or whatever, they'll do that.
I think it's best for, in this case, I did read the packet. I'm assuming most of you all did as well, but for the whole group,
You
maybe
did read it?
I did read it. Maybe a quick highlight from the claimants, whether you want to represent them and say what the quick highlight of what the challenges are, and then we can ask the property owners to respond.
Of course, yes. So my clients live at a higher elevation, just abutting the property of the tree owners, and the trees, the oak trees that we're dealing with now. There were 3 oak trees, and three of them affect one of the couples, and only 2 affect Hazel Hung, who's another owner right next door. But they are a certain variety of oak that the tree owners planted within a year of buying the property, and that was in 2011, so 2012 or so they planted them. And one of the tree claimants, Marcy Cravat, noticed that they were either on the way to be planted or they were just planted, they were baby trees, and she pointed out to them that they're going to grow very large and will block their views. Please move them or plant smaller trees. And so that request was made. It essentially, that was in 2012, so that's a long time ago. And over the years, the trees have grown, and I interjected another bit of the history here with Ms. Hung only. What happened there was, and I interjected it because it is important, there was also a pittosporum, which most people know what they're like, and that was growing very large, and that had been already blocking the view of Ms. Hung. The former owners at her request said, sure, you can have it trimmed at your cost, which she did. And then soon after, the new owners, the tree owners, moved in. And I apologize if I'm not just saying their names, only because they have kind of involve last names, so if it's okay, I don't mean any disrespect. So essentially that pittosporum grew, and it was, the oaks weren't that big yet. They hadn't yet grown. But because the tree owners refused to have it cut down, it was one right in the middle, blocking the Golden Gate Bridge, and definitely blocking the view. And unfortunately, they wouldn't agree to remove it or trim it down even. In fact, when it does get trimmed, it grows even more vigorously, as you may know. An arborist will tell you that, especially with pittosporum, they tend to be hardy. They'll grow quickly. So it compelled my clients to file a lawsuit, or my client, Hazel Hung, to file a lawsuit because at the time, this panel wasn't even, I guess, in anybody's dreams at the time, but so we did file a lawsuit. And after about a year of contentious litigation, we finally were in mediation, and they agreed to take it out, which they did. And of course, when they took it out, we could see underneath it, sort of obscured, one of the oaks. And then those oaks kept growing. And at the time of the lawsuit, we named the oaks as obscuring trees. We identified them, but they hadn't quite reached above the roof line of the tree owners, so they weren't technically blocking, and we did ask if they would trim them, keep them trimmed down, but they didn't want to agree to that, and so that didn't happen. We wanted to settle the lawsuit at that point, and that's what we ended up with. So then now the trees have grown, and as Ms. Cravat pointed out to me a few minutes ago, she had asked, asked for them to be trimmed and so forth, but there was constant rebuffing and non-cooperation. If the trees had been trimmed in an appropriate way according to our arborist back when we were babies and then growing, they could still be perfectly healthy and wonderful and nicely formed and not block the views. But because there is, and of course, as everyone probably knows, a live oak or a coast live oak will grow very big. There's one next door to Ms. Cravat and Mr. Overway that's giant. So, and the property, Hazel Hung's property and the tree owner's property, those are relatively small lots. They're not huge. And so those trees are misplaced, actually, because they're just going to grow so huge. They're already crammed in there. And despite a promise that was made to Marcy Cravat, one of the tree owners, Leslie Jacoby, said she promised she wouldn't do anything, plant anything to obstruct the views, but then that promise was never obviously fulfilled.
Okay.
So that's a brief statement. If it's okay, I will stand here and call you. Okay, because I am a little hard of hearing, but I also have a bad back. I don't know.
You need a chair.
Yeah.
Yeah, well, if this is a bad spot, I'll move over to somewhere else.
You're fine. You're fine where you are.
Over here.
I just want you to be comfortable.
Yeah, I'm
Yeah. Okay.
Before we talk to the property owners, does anyone on the board have any questions for the finance? Dahlia? Good. I'll take that as good. So are the property owners here?
All of us are here.
Nope. I mean the property, people who own the tree with the oaks. You guys want to come forward?
Hi, good evening. My name is Dr. Leslie Jacoby. I live at 187 Purdue. And I got the notice, and I want to just stick to the points. I do want to point out that every single one of our neighbors who surround our house, who have nothing to do with this, are here to, hi Ying, how are you?
Be supportive.
So they're here, and quite frankly, my husband and I do feel that they are bullying and gaining up on us. But let me address the issues. There are, I read very extensively, and I do want to just make one final comment at the end. Oh shoot, because I'm not sitting here. Actually, I can do it from my, no, I also have a very bad back. Number one, first thing on your list is that they are entitled to a restoration of their view at when they moved in. Hazel Hung, when she moved in,
When did you purchase that home?
I purchased the home in 2011, and I am a licensed real estate broker. I read every single document. There was nothing in there that I had to not have trees in my backyard or anything else. But I would like to go back to the first point, that if you go to Google and you look at 2007, 2008, 2009, 2011, they had a view blocking. Okay, so when I moved in, the house had been a rental for 40 years. There were trees that were too close to my neighbor JJ's. That was a fire hazard. I had to remove a plum tree when it started dying. But I actually, let me stay focused. First of all, that's the goal, is that it should be restored to when I moved in or when they moved in. If you look at those Google documents, they didn't have a view. In fact, I have improved the property. Number two, it says here that today that you're going to either issue a binding statement or you're going to have us sit down and maybe arbitrate. First of all, I did not agree to a binding anything. This is in essence an extension of the lawsuit that was done previously. So the only way this is really going to be resolved is by a lawsuit. So and I read the ordinance, I appreciate your advice and your suggestions for mediating this, but it's going to be in a court of law. I do not have neighbors. I have bad actor neighbors who, I did want to say this idea I made a promise to Marcy is a lie. And
Let's let her talk.
yes. And there is so much evidence of my neighbors harassing me. I've had BB guns shot at me. My one neighbor tried to hit me with his car and came within 6 inches, was reported to the police, but they decided not to prosecute because I technically had not been hit 6 inches. So this will only be resolved in a court of law. And my husband and I are prepared to deal with that. I did bring some evidence in that. One more thing is that my husband and I have taken very good care of our property. We have upgraded the property, so with Contra Costa home improvement ordinances, we had to deal with PG&E, dealing with all the issues with roofing, upgrading knob and tube, all of that. That was done all with permits. My neighbors were difficult to work with. They were very difficult to work with. But we have improved our house, and that includes our garden. And we have finally got it to a place that we find peace and joy in our garden. We continue to maintain our trees, trim them, and I do know in the ordinance that was in 1984, and I did read the new ordinance of just recent. I do continue to thin them out so they can see through, and quite honestly, the view they have today is better than when I moved in. My house is in better condition. The trees are they are healthier trees than what were there before. And some trees were planted by squirrels. Some I planted, but nonetheless, all the trees have been taken care of. And I think there was one more thing, sorry. I think that's actually it. I really thank you, and it's unfortunate. I think that this issue will only be resolved in a court of law and going all the way to court with jurors and everything. And I'm really sorry. And please keep in mind what she just said, that I made a promise to Marcy. That's a lie. They're not welcome on my property. We go through lawyers. Hazel Hung continues to try and text us and show up at our property. They need to go through our attorney. They know we have an attorney. They play games. This is going to be resolved in a court of law. And I thank you. Thank you very much for listening. And I appreciate your time.
Anyone have any follow-up questions for?
So since this is new to us, and like while both parties have been speaking, I've been trying to make sure that I have a full understanding of the ordinance as well as the explanation that was made to us in our last meeting. And both parties can choose to make this decision binding, right? However, if both parties don't agree to it, if one party does not agree to binding, my understanding is we can still make a recommendation, it's just not binding.
Right.
And so just want to confirm that everybody understands that, including the homeowners, that we can still make a recommendation, that recommendation can still be used in a lawsuit, right? I don't know how the courts will weigh that recommendation, because again, this would be one of our first recommendations, right? So, just to call that out.
David or Dahlia?
No, I'm fine.
Okay. One thing is, what we're looking at primarily is, it's not important about all the challenges you guys have with trying to rectify this. It sounds like the neighbors don't agree on everything. Promises are not, that's not what we're here to discuss. Like whether someone promised something or not, that has nothing to do with. But what we're ruling on is, when were the trees planted? What was the view in 2006 when that house was purchased? And the approval was from 2006. And then that is the view that needs to be there permanently going forward. That's what the ordinance says. And so
Unless some agreement by both the parties. Yeah.
unless there's agreement by the other parties. So what we would need is documents that are showing the views, current views, and the views of when you guys purchased the house. I don't know if you have that now, if it's on your phone, or if you can print it out or something like that. But
Some pictures here, I think. In this
is it from the original one? I didn't see it.
I don't know about
Yeah,
we have some.
2011.
Well, 2011, it's May 2006. That's what matters, not 2011.
Excuse me, you're looking for whose property?
So the property, so the claimants, they're entitled the view they had when they purchased their property, not in 2011. When that's a
Of
different.
course,
So
yes.
so it's when they purchased it.
Here's
So
the view from whether they're Zillow. That's the view.
And also,
We have a view.
we did produce,
this is when was this?
That was when they bought their house. That's the year they bought their house.
2006 or 2011?
2011.
So we need some
2006.
2006 is the title. So the point is if there was other trees that were blocking your view when you purchased the house in 2006.
When we purchased the house,
Are you the are you
Claimants.
are you the
when we
claimant?
purchased the house, a lot of the trees were lower, and we talked with Layla that owned the property that they bought from, and she would trim them down periodically. So I don't know when a picture was taken.
And you can see in that 2011 picture, there were no significant trees in that backyard. There was nothing
Nothing.
that big.
That's 06.
And that's when they moved in,
You can see
the Leslies. That's when the Leslies moved in.
that's the tree difference between those years. No, that's
Wait, is Hung? Are you? Is Hung?
This is Hazel
That's
Hung.
Hazel Hung.
I'm Marcy for that and Kurt Overway.
Okay,
We're
so
married.
Okay. So this is the different.
So it's just different perspectives. Yeah. Got it. Yeah. So that's gonna. This one's coming this direction here. This one.
So just so everyone understands, in 2006, the view that both of you had at that time, both houses, is the view that should be restored according to the ordinance.
Our trees were trimmed down whenever we requested. What about your trees? Same.
So if you have pictures from when you first purchased the home, or
No,
within
because it
reasonable
wasn't-
time.
No, do we?
excuse me if I could interrupt for 1 second. The ordinance does say, a view that's been lost should be restored, right?
Yeah, that's what we're saying.
But,
Yeah.
yes, but as it happens, in fact, there's a case that is precedent here. The court in that case, it's called Conn versus Price out of San Francisco, very similar ordinance. They said it doesn't matter if at any time during the occupancy and ownership of the view claimant's properties, the view was cleared. That gets to be restored, however it was cleared. So I think there was one tree in the past that was in the way, but it did get cleared, not connected to this at all, but it got cleared. So they had panoramic views. And the arborist report from Dennis Inigas, who I included, he was the arborist who helped when that Pittis Forum was an issue. His photographs definitely show that the Pittis Forum was the only thing there. It was the only thing obstructing Hazel Hung's view. She had a panoramic view. So that concept that it has to be on the date that they bought their house.
Well, that's what
They
we
have-
have,
I know,
as
so-
for our board, that's what we go by.
So
But that's
regardless,
not the ordinance, and it's not the law.
It says it right here. It says, the claimant has the right to seek restoration of view from something that exists on the claimant's property when the claimant acquired the property.
Right, okay.
that's
Has a right to
2006.
review, right, okay.
Yeah.
So it's not the view in 2011, 2008, 2009, 2011.
Well,
So
but that's-
all, this is what the ordinance says, so this is what we have to go by. So what we would need to see is what the views were, within a reasonable time within when they purchased the home. Because it's not when the neighbors purchased the home in 2011.
Their
Because
testimony.
we have no way to know what was.
Their testimony here, it's not under oath, it's
Yeah,
not a
I-
court of law,
Right.
is sufficient. They may have said that we
Sorry.
didn't have views, that the views were blocked, but there's no evidence that they ever saw from my client's properties what the view was. You can't just say, oh, they probably have a view. That's not the case, but the law is very clear that it's any time during the occupancy, because some trees get.
We can only go by the
Struck down.
ordinances in front of us.
That's what
But
We're not the law.
Yeah.
We're not a judge, we're
Yeah.
not a jury, we're not the law.
Okay,
So
then,
that's, then
then
if
it-
the
it-
law is something different, that's something the lawyers have to discuss, not.
then
not
their
marketing guys.
their statements as to what they had, panoramic views, is evidence.
But the ordinance says that.
Yeah, long day. Mm-hmm.
Let me mute.
Thank you.
There you go.
It doesn't say that, the ordinance doesn't demand that they have evidence for all of these things, meaning
Well, no, we can
documented.
decide whether or not we need that to be able to better understand and make a decision or recommendation.
Because we don't know this, like this forum, which was clearly an issue at one point in time. We don't know the impact of that. My guess is at some point these live oaks are gonna exceed what one Pittis forum ever had. I'm sure
Of
at some
course,
point.
yeah.
Right now, we don't have a before and an after. We don't have a here we are right now, here we were in 2006. For us to be able to say something has to happen, we need that information.
Where does 2006 come in?
That's when they purchased their house.
No, we purchased it.
Not you. It's when the claimants purchased their house. The claimants are the ordinance says when the claimants buy their house, that's the view they get. When she bought the house, it had nothing to do with it. It's when
I
they bought their
understand.
house. So for us to be able to say someone has to do something, there has to be restoration, we have to have a very clear understanding, or at least a reasonable understanding of what it was in 2006 when they purchased their home. And Ms. Hung, I'm not
What
sure.
about Miss Hung? She moved in 1985.
1985 is Hazel Hung.
So again, does she have? Do we? I mean,
Yes, there is a.
if there's
actually,
pictures from these times, then she's entitled to those views.
We produced a photograph of an appraisal of her property that was done, I forgot the year of
Is
it.
that in this pocket?
Is that in this packet?
Pardon?
Is that in this packet?
Yes,
I have it.
right.
Where,
It is.
so which, like,
Can you
I
guys-
tried to,
I don't
it's
have it
a
right
lot,
now.
you've provided us a lot, so like,
This is an
I was trying
extension
to
of
find
the
it.
previous lawsuit. Can I just show you two things? You're asking about the tree. This tree here was close to 75 feet tall. It's a cedar. It was within 10
just
feet
to-
of his, okay,
I get
but
it.
this was in, when I moved in, this is from the Google, and you can see.
I just want to see. All I want to see is in 1985 and in 2006, what were the views? Because those can't change.
Well, I can assure
So if we
you,
have the
this tree
pictures-
was so large, it
But-
was blocking the view. It
But
was over
again,
100
it's hard for us to. There's a tree here. There's a tree there. Then there's trees missing. There's new trees coming in, and we.
I will have my attorney contact you.
I think
You can have, it would take my card.
Yeah, why don't we talk to Joanna? So, hey folks, I think, again, this is our first time doing this, so we're not professionals. We're definitely not lawyers, so we have to take this, we have to take the arbitration, or sorry, the ordinance as how it's written, and then we have to do the best based on what you guys can produce from whether it was from some point in time around when you were purchasing your house.
Well, from 1985, I don't know how you'd find photographs of that.
That's what,
There is a picture from the 2006 appraisal report.
That's the one that we have that, and then we have the same, from the same perspective of what it is right now, we can say that that's the view, that's what has to happen. That's what we can roll on. So,
I believe they purchased the house and moved in on 2007.
when I said 2006 because
2006 was when I had the
oh, the appraisal
report.
done. Okay.
2007, I believe, was when they purchased their house and was
But so you moved in 1985, and then you moved in when?
2006.
Okay, so those are the dates that we're gonna measure off of, is the 2006 and the 1985, because that's when you kind of said, this is a benchmark of what you're allowed to do. Now, in that period of time, trees might have grown and gotten topped, and grown and then gotten taken down, right? But that point is what, according to the ordinance, says that we can say, yes, you need to get that back, right? So, I would like to make a motion, actually, to recommend, revisiting this next month. If you guys can pull together some of that documentation for us to see it, so that we can judge based on what you provided, what's today, versus what was then for those 2 years, that will allow us to make a determination of whether there needs to be some kind of restorative action.
may I also say that if I had known that you were going to.
I second that.
Oh, sorry, you made the motion.
I made a motion, she seconded.
All in favor?
Aye?
Aye. All opposed? Motion carries.
Okay.
If I had known that you were going to say that it has to be from the point that they purchased their property, acquired their property, which is what you're saying the ordinance says, I would have obtained aerial photographs. The Army has every single square inch of this East Bay.
And you still have
covered.
that opportunity.
Yeah, now I'm just saying
Yeah.
that I will do that.
Yeah.
And that can be shown, and we will.
Yeah.
I think that's the best way. We want to be fair.
But you're
And,
talking about 2006 and 7 because that's when Cravat and Overway moved in?
So the views of each homeowner,
Yes.
they're entitled to whatever it was when they moved in. So if you can imagine a world where, I'm not saying this happened, but if 1985 there's huge trees in front of her house that 10 years later got cut down, then the view she's entitled to is the big trees in front of her house, right? But if there's no trees in front of her house and she had a full view, she would be entitled to that full view. That's what the ordinance is saying. But it's when she first purchased the house. The idea being you purchased the house with an expectation, you paid a price with an expectation of enjoying this view. If that gets encroached upon, you're still entitled to it. That's the idea of it.
Right. And not everybody takes photographs to document these things.
My neighbor told me to the day I moved into my house, so it's, I had a good neighbors.
Just so that I understand a little bit, if you live in your house and your view is improved by the removal of a tree, you don't have the right to the improved view. Someone can just plant another tree.
But
Right.
it's a super important question for me personally, because that just happened to me where someone had to remove a tree and all of a sudden I'm like, wow, this got really good. So I got very lucky. I was disappointed to see the ordinance actually, they stick to the date I purchased it. So in theory, like in my case, because I do have that case, I'm not entitled to my current view. I'm entitled to the view that I bought the house with, which was worse. So it's the idea being is they want you to get what you bought into. You bought into this view, so you're entitled to that. You're not entitled to more, you're not entitled to less.
They also want homeowners to have, this is our understanding again, like this is not, what we're saying is the ordinance is we didn't create the ordinance, we're just tasked with implementing it, and if this was, we were voluntold, just so you know. So, if somebody, like you're allowed to have the benefits of a tree too, right? And so the difference is basically, okay, there's pros and cons, right? So the homeowners might want a tree, they want the shade, they want whatever benefits, they want the fruit that come off of it, right? And so if, let's say, there's this huge fig tree because they can get really, really big, and the person loved those figs, and then it got diseased and died. That person has a right to plant another fig tree and let it grow big. You know, that's the idea behind it.
I do recommend anyone interested, because Kensington trees in Kensington are a big topic. That if you go to the Kensington, if you just Google Kensington tree ordinance, it'll take you right there. It's very clear. It's educational for me. I'm new to reading it. I knew it was an issue when I moved to Kensington, so I encourage everyone to read it.
Who wrote this?
I'm one of the people who worked on it, which is why I was really interested in attending the meeting today to see how the first meeting would
How did we
go.
do?
Well, I'm gonna write a bunch of comments to
Okay.
Supervisor Joya after this meeting, about things that I see, but, you know, we've had a tree obstruction ordinance in Kensington since 1984, I think somebody mentioned that. And, nothing has changed as far as the intent of the ordinance. There's always been a policy in Kensington that neighbors should try to avoid obstructing a neighbor's view. So, but not to remove trees if you move, you don't have a right to a better view if you move in because there was a tree, across the way or whatever. But what we wanted to do with the revised ordinance that, we're talking about tonight is to really try to find ways that neighbors could resolve the conflicts around these trees without having to go to court, because it's very expensive, and obviously I'm hearing a lot of emotion here, which I feel really bad about for all the neighbors who are involved in that. But we really wanted to find a way to resolve that. And these are just issues that I know some people are able to work it out and some people can't. But as far as some of the factual things that you're discussing tonight, I think it's true. We had a discussion when we were writing the ordinance whether we should have a date for, like, if the tree was in existence on this certain date back in 1984, that tree has a right to stay there, and too bad if it blocks your view. But then we've changed it now to be the only way that we could find like something that made sense was, okay, the date that the claimant moved in is, if they had a view that day, then that's the view they bought their property assuming they were going to have. Subsequently, people do come in and plant trees, which I thought was the issue tonight. And so when you're doing your fact finding, I think you really have to look at, maybe there aren't documentations of the date that somebody moved in, but if it's talking about a tree that was planted subsequent to that, and you have documented evidence, do you consider that or not? I think, logically, if somebody if somebody moves in 2007, a tree grows, in 2011 or gets planted in 2011, well, that still means that the tree was after the original claimant, so you can evaluate that, but the question is, as long as you're just looking at, you're not establishing a new view right? You're not saying this person gets to have the trees trimmed or moved because they want a new view, but the view wasn't obstructed prior to this. So,
So I think that we're trying to interpret the ordinance as drafted is basically that it says the date that the claimant had purchased the home or moved in, right? That a lot of things happen to our flora, and so things can grow up and die in that period of time, right? And so there's going to be periods of time where people like Adam here that all of a sudden they have a great view, and then somebody else might buy that house, and want to put a tree there, and it might grow into his view again. Right. And so does that establish a new right? Yeah. Because so basically he didn't have that view before. He got it, loves it, but a new person comes in, he didn't have it before. They did the research, said actually he didn't have it before, so I can put a tree if I want to, right? That's how we're interpreting the way that it's written.
Yeah. And because we can't establish what was there before, and you know, based on what they were saying, there was something. There at least was something there that was a problem before when they moved in. We just don't know what that extent of that was.
I think in this is a slightly different situation. I'm not trying to advocate on one side. I'm just trying to think. I mean, it's really your job. I'm not on the MAC. But the idea was that, you know, in a case where I think the original ordinance was like really with the mind of like what happens when trees are already like planted, like they've been there for a long time, like redwoods, they grow, you know, incredibly high. You know, so they might start, you know, you move in, that tree's not really blocking your view, and all of a sudden it's huge. Well, you don't really have a right, I mean, you have a right to only to cut it to where, you know, it was when you bought the property. But if there's no tree there, and the tree is, I mean, you have to establish when these trees were planted, partly, to know, you know, in conjunction with the time that the person bought the property. And you're probably going to get into more of these kinds of situations where you're going to have to bring an arborist to determine like how much could that tree have grown during that time.
Right.
I mean, so, you know, to establish whether because some of these cases, this is like maybe more of a, you know, no tree to big tree, whereas you might have a situation where there was a tree and then there's an argument about how much it had grown over time. And, you know, again, so
I see where you're coming from.
Yes.
I know that we have another project to review and people are waiting to do that one, so we're like, as much as we're nerding out on this and getting interested in it, I think we'd rather just stop talking about it.
Quick question. What about people who planted trees when they moved in? They had no trees in their backyard hardly when they moved in. So, I mean, you're saying it matters when we moved in and when Hazel moved in. What about when they moved in? There were no trees in their backyard that were blocking anybody's view when they moved in, because we worked that all out with the previous owner. So when they moved in, there were no trees. Why don't they have to, that's when they moved in, why don't they have to protect that?
I think it's good feedback. I'm not saying I disagree or agree with you. I'm just saying that we have to only go off what's written. What's written is very clear, and it says you need to provide evidence. It says you need to provide evidence.
So what if we provide evidence of theirs when they moved in?
Because that's not what the ordinance said when they moved in. Might be different. The ordinance says when you moved in, you're entitled to the view when you moved in. So it's just not written that way. I can't say whether that's right or wrong. I'm just saying that that's the way the ordinance has been written.
Well, what if they moved in and there were big tall trees there and they wanted that because that provided them a barrier from having to look at the neighbors up on the higher level? Why wouldn't they be entitled then to have those big trees? But they moved in and there were no trees there.
That is another scenario that you can look at. They claim, like, let's say that they want to have privacy screening from trees, right? And those trees, for whatever reason, died, right? And they wanted to replant trees. They have a right to those trees, right? Because and they have a right to those trees to go to the height that they were before, right?
Okay. I think we probably can find something in some old archive of 1985, which I'm pretty sure there were no trees because the neighborhood was being built, so it was all flat and being built. So we will look for that. We'll also go back and we'll look at our view from that time period when we moved in, because it's possible that there's some old Zillow photos of that. But, you know, I'd also like to share that after they moved in, she came up to the house, up to my house, found my house on the next street up. By probably looking in her backyard what our house looked like. And she came in with a card with her picture on it of her and a falcon. And she told me she was a falcon person and she wanted to be fast friends and she was gonna be planting her backyard and she wanted to see my view and she promised me we're gonna work together, she said. We will work together. We're not gonna be blocking anybody's view and everybody's gonna be happy. And she's calling me a liar. That is just not true. It's just not true. She told me not to worry, and when I looked over her fence and saw 3 oaks in their gallon things, I said, well, what are those? She said she had a vision, and she wanted her vision to look like Santa Barbara. And she was gonna put in these oaks and allow them to grow because that was her vision.
We understand everybody's point. We do have to move on to other items. We made our motion, so we'll put it at the agenda next month. We'll see you next month. We understand. Thank you, everybody.
And we look forward to your notes and feedback on,
Yes.
Yeah.
on how this
What
went.
is the date next month?
It's the last Wednesday. So that would be May 27th.
Okay. Let's move on to 0 Highland Court. What's that? Oh, what did I call it? Highland, that's what my house is. Highgate, okay, Highgate Court, and let's start with, who are the property owners and people building? Anyone here? Oh, here we go.
Hi, everybody.
Hi, how are you?
How would you like us to?
Right there's
Right, yeah, it's great. There, however you feel, gives us a good idea of.
How we do want to take? You can take one of these chairs to put your pictures up if you want to.
Yeah.
Well, you want to sit there?
Yeah, do you need it?
Whatever pleases the.
Whatever
We just need to see it. That's all. So.
Okay, so we have a screen here, so that would be better.
Yeah, maybe like at an angle, I believe, just so that they could see as well. So,
Probably.
trying to think of like the best angle.
Why don't
Because
we
next to you, maybe she could shift over, and in that space around there, I just want the people who are on Zoom to also view some of the images.
Very good.
Yeah,
I just wait to put the boards up like this.
put it around there at an angle.
Yeah.
Yeah, I just want to make sure everyone can see.
Yeah. Screen to see, so you guys
You can slide one of these over if you want to as well. These chairs. Yeah, any of these blue chairs.
They're a little heavier duty.
Just slide.
Oh.
Did that catch on?
Better.
Oh, that's actually connected.
Pull that away from
Oh,
that.
gosh.
What is that? Oh, I guess there's little these things.
Okay.
Almost tore the whole library down.
It's a.
It looks like it's still caught under there.
It's actually connected.
It's connected to it.
Why don't I roll one of the ones that we have?
Okay, that's good.
Okay,
Sure.
I think there you could see the image there.
You guys can see it
That-
too.
Yeah.
Hey, while we're waiting, everyone here who's here for this project, want to read through our role in reviewing these properties, specifically the zoning variance requirements. So special circumstances must exist before variance can be granted. Variance cannot give special privileges that other properties do not have, nor can it find a land use that is otherwise prohibited in the zoning district. By law, 3 findings must be made to grant a variance. That any variance authorized shall not constitute a grant of special privilege inconsistent with the limitations on other properties in the vicinity in the respective land use district in which the subject property is located. And that because of special circumstances applicable to the subject property, because of its size, shape, topography, location, and surroundings, the strict application of the respective zoning regulations is found to deprive the subject property of rights enjoyed by their properties in the vicinity within the identical land use district. And that any variance authorized substantially meet the intent and purpose of the respective land use district in which the subject property is located. Failure to use so shall result in denial. So one thing to note is we don't review everything that has to do with building a property. For example, we're not engineers. We can't comment on engineering. We can't comment on, I don't like it because they want a pink house. And that's gonna clash with it. That's not the kind of thing that we will review. We are gonna review, how the property impacts the rest of the neighborhood. Stuff like, I know there's some people mentioned things about fire lanes, stuff like that. That's not something we would comment on. If there are things that we don't comment on, would be handled at the county level. So there's be a few things people will discuss at this meeting, and I might stop, and I'm not being rude, I might stop you and say, I'm not saying it's not valid, but it's not an area that we have jurisdiction over. We're experts in it, we can comment on. There are some things we can't. So we'll stick to those, okay? So just because I know it's getting late, and the last one was pretty long, and in this case, I'll probably step in a couple times and say, I understand this point, but we can't address that. Just make sure everyone understands.
The other thing that I would like to add to what Adam's saying is that we've been at this for a while now. Like, I think like I'm in the middle of the pack. Like, we've been around doing this for a while, and I think that there's a lot of strong feelings when these projects come up, and our goal is to try and find a path where everybody can work together to get to a good resolution, where that helps the home, like the property owners do what they need to do, and the neighbors live cohesively together as a community. Like, you're gonna have to live next to each other, so we're gonna try and find a way to get there. In many cases, that means some kind of compromise, and so that's something that we do try and figure out ways to create an opportunity for you guys to talk to each other and compromise. I can tell you that for new builds on vacant property, like there have been ones that have moved through very, very easily. Like there's one that just sailed right through last year. There's others that have come to us 6 times. So they've gone, they've worked on some more, come back again, gone, come back again. So like, I just want to set people's expectations that like, we're not here to basically stamp something and say, good to go. We're here to try and figure out what is the best, like what can we do within these rules and how can we help you solve get you guys a little bit more aligned. And in general, at some point, everybody's gonna be a little pissed off, okay? But hopefully not so much that you can't live together, okay?
Thank you. Okay.
That's really well said. I've been in this for a long time. You're right. I mean, nobody really gets what they want. It's a compromise. Hi, everybody.
Hi.
I'm an architect representing the owners of this lot, Dale and Daniel Power, right here. They've been living at just above Highgate Court in a home there for 36 years. Are you Joanna?
Yes.
Oh, pleasure to meet you.
Nice to meet you.
And they currently want to move out of the house they're in now, which is right behind them, off Norwood, and they want to move into something that has an elevator. And they have lots of kids, and they love the area, they love their neighbors, and they just want to kind of develop this lower property. And it's been a challenge. This house, the lot is very steep. You can sort of see it here. It's a 1.5 to 1 slope, so it's from the street goes up, very steep. So it's been an extreme challenge to try to find something that they could park, not impact their neighbors, get an elevator in, and live there and age in place. And that's the challenge. For an architect, it's a big challenge. And we've been through 4 different iterations of this. And this is what we've finally come to. If you can see it from the back there. I don't know if you can see it or not. But, the project, because of the steepness of the property, we're going to need some variances on the strict interpretation of the zoning code, which is if it applies to, it's written in a general sense, but when you have really steep lots or properties that are impacted, the zoning code in the county allows a variance to proceed if it tries to balance everybody's use of their property. It's a 14th Amendment, equal protection type of thing. So we need four variances, or who knows how many we're going to get in the end, but we're looking for 4. This is Highgate Court here. North is this way up. The house is oriented kind of like that. And the different colors represent the different variances we need, mostly in front, so we can be able to fit this house into the hill. The write-up from the county is incorrect. I don't know if you guys have read it or not, but they must have done some calculations preliminarily, but they're not correct at all. So I just want to correct it for the record. In the write-up that the county gave everybody here, it says that the proposed development results in a gross floor area of approximately 3,360 square feet, and that's incorrect. The gross floor area is 2,869. And I've got all the calculations to prove it, just that when the county first did their run-through, they made some mistakes. And then there's a threshold that the county and KMAC have determined that once you exceed a certain threshold in floor area, that if you exceed that threshold, then a public hearing at the county level is required.
That's this. So all the square footage does is it triggers this meeting. There's nothing in the ordinance that says you can't have a building that big. It just means it triggers this meeting.
But it turns out we're under that threshold.
Yeah.
And we're under it, we're at, the maximum you can have on this is well, they calculated all their floor areas wrong. We're under the threshold.
It says 2,900 is the standard threshold. So.
Yeah, they're wrong on that. We're at 2,993, and no, the maximum threshold is 2,993, and we're at 2,869 on our gross floor area.
Okay.
Yeah.
Well, we would have triggered the meeting with the other variances regardless.
Just set the record straight.
Yeah.
I want to go to this one drawing here that just shows everybody the challenges that we have. This, I don't know if you can see the three-dimensional drawing here of the foundation, the cuts, but this is the cuts. There's a huge cut, the first cut of the garage, then another cut, and that's at 12 feet. We're just above grade there. So to be able to build this thing, that's why we're asking for a setback relief in the front so we can build a garage. And that's like 22 feet. So we're not like being excessively.
What are the heights of the two cuts?
This is 17 feet, and this is 11'6".
Okay.
And similarly on this side we have 11'6" here, and that's it. That's the cut there. But it's been a challenge. One of the things that we noticed in the building in the code, and it's written up in the write-up that we want a 2'6" setback or something like that on the sides, and that's incorrect as well. Okay. One thing that's interesting that I didn't know, maybe you don't know, but the county now counts the setback from the foundation underneath the ground. And that's not done anywhere else. You know, when you have a footing and retaining wall, they're counting that footing as a setback, and there's probably no houses really in Berkeley or in Kensington that actually are built that way. But anyway, the setbacks to the house, the part that everybody sees, we're within. We're not asking for relief on that. We're at 8 and 9 feet. We're at 15 feet, I think.
So you're on this side, you're 8 feet away from the property line.
The house part, yeah, the foundation sticks in.
Yep.
The house part is 8 feet here, or yeah,
Okay.
it's 7'6" here, and it's 9'6" over here.
Okay.
So it's still inside it still requires a variance, but not.
To get the footings.
Yeah.
But the house part that everybody sees conforms to the ordinance.
Is that retaining wall or footing?
This is all retaining wall.
No, the one that's close to the property line.
That right there is retaining wall.
So why cannot we, within the.
It is, this is an old version. When we talked to the council, good point, you have good eyes. We took that, it used to be here, we took it, and we just got it back in. So we revised that, this is an old, it's really good eyes.
So, I guess that's we're not at the question spot. So like you can still have some more time to present if you want to, but I definitely have a number of questions already. So.
I'm sure everybody does. side view of the massing. This is the area where we're trying to provide some off-street parking. That road is really narrow. When I drove up there, it was like, wait a minute, we gotta do something here. And we also need to think about how we're gonna build it. So the first thing we need to build is we need to build a staging area so that we don't impact any traffic up that street. And that's kind of where this starts coming in. And then that staging area becomes permanent off-street parking when we're done. So we have to think about how to do this without impacting anybody. That's a real challenge. So,
What's the total square footage of the lot?
So it's not time for that just yet, so we have to let him kind of do his thing, and then we ask questions, then you guys talk.
Yeah.
Okay. Go on.
There's a little bit more of a cross-sectional view through the garage showing those retaining walls.
Okay. Okay.
And that's just that's the more of the architecture.
Great.
And it was designed to sort of fit into a region style up in that neighborhood.
Okay. Do you have anything else?
I mean, I could show you more drawings, but perhaps it might be better time spent to answer your question.
Sure. Well, so for right now, the questions are just going to be the board specifically, and then we'll open them up to the public.
Okay, do you want to go first or want to go first?
Go first.
To what extent have you discussed these plans with your neighbors?
Hi, I'm Dale Power, this is Mel. In fact, I just today met with our next door neighbor above, Ali Gardisi. He's seen the plans we've gone through, and he said, I don't think he'll come to the meeting because he says unless the plans got changed, he says he's very happy and pleased with it, and we've gone through there.
Is that from Norwood?
Yeah.
Your neighbor from Norwood?
Yeah, right, he's right over Manhattan. The other thing, we did, and I sent a little letter what we're doing and explained, is that we sent a package of all the plans with a cover letter to all of the surrounding neighbors. So we sent them to the Samosi, we sent them to Bob next door and Pam.
He did not get any letters.
None of us got that, none of us.
We didn't.
Not
Except
one
for
of
me.
us.
None of you got the
Not
packet
one of
that,
us. Not one of us.
Last week,
what?
I got one last week,
One packet?
one packet.
Cause we sent an assistant with the packet, and did you get the packet cover letter that I put in? That was sent to Lee next door, it was sent to Bob, sent to, ahead of time to Pam, and we got a call from Bob or somebody that wanted to have an extended survey that our assistant sent to one of you owners. So I don't, and then Pam Drake on the one side also had a packet put in her mailbox, and then he thought so. And I used my assistant, so that's all I can say here.
So it sounds like there hasn't been a lot of dialogue with the folks on Highgate Court.
Not about these plans. Over the years that we've owned the lot, we've mentioned what we're trying to do in Halifax.
But in the letter, they left our number and everything to call if they had any issues. or
Yeah,
any
we said,
questions.
we said give a call, we'll call back, and so I don't understand there, and our assistant Sherry, Stacy, did say that she got a call from one or two that she gave out to, and then followed up asking you for the full
survey.
For the full survey, not just the ones for submit, so that's all I know.
And this was something where you asked your assistant to do this like last week, or like how recently was?
Well, I asked her, I think a week and a half ago when we were there, so as soon as we got the plans from Jonathan and the ones, then as soon as we got that, I drafted short letter here, saying what's what, you can call us, and sent them to just the surrounding ones. The one in front, the two on the side, and then above, and the one above.
Got it.
And the one above, of course, I live next door, so we've been talking.
Right. So then, I guess my next question for you is, it looks like since folks haven't had, like, I read the letter that that we got. Sounds like folks feel like they need a little chance to breathe and think about it, you know.
The letter from me or another?
From your neighbors. That,
Okay, and I haven't received it.
Yeah, and so that was just sent to the KMAC, I think. I don't know if it was sent to you. This is what I think was addressed to us. So, my question along those lines is like, maybe what would be a good idea is for us to use a little bit of time right now to just share some of what you're trying to do with your neighbors, and then maybe spend some time over the next month talking with them, and then we can talk about this again next month once you've had a chance to hear some feedback and see whether or not there needs to be any modifications to the plan that you think are reasonable, that they're asking for, that will allow for some compromise, so that it makes it easy for us to do our review.
Yeah, we received a pretty detailed, and it sounds like you guys all work together on it, a pretty detailed listing of things that that are challenges to them. And I think, you know, some of them you might be able to compromise with, some of them might be hard or impossible to, based on what has to be done, and that's, I think, where I think you might be able to get to a place that's a little closer, and maybe get people more on the same page.
Yeah, let me use this time to let them know our responses. People put in a lot of time.
Oh,
Not
of
only
course.
the plans,
Yeah.
let's just
Before you, we'll get to that. Let me just, I'm just trying to set the stage for the next step's probably not gonna be a decision from us. The next step's probably gonna be you guys trying to find more of a compromise, potentially, and we'll probably talk again. But yes, absolutely, you guys will have your chance to talk. Any more questions for you?
If you want, I can make a couple comments to that, finish yours first.
Yeah, those are my two big questions, because I'd say that, like, you know, given my experience being on KMAC, you know, and I'm not going to speak for the other members, is like I personally prefer to see a little bit more engagement between the neighbors before we do a full review and make a recommendation. And so, like, if you were to say today, I want a decision, I would go no on it, because there needs to be more engagement. So that's why I'm just trying to give that expectation that, like, hey, if you want to kind of go bulldoze ahead, you can, you know. That's so, like, you're well within your right to do that. It's just more like, usually what we're trying to do is kind of create that, make sure that the community is able to kind of find that middle ground. Okay?
Well, why don't I make a few comments to all of it? I recognize a lot of faces, and in fact, I think it was a few years ago we were worried about dirt coming with both the common area and all onto the street, and I met with the neighbors there, and we looked, and then I said, I'm gonna be building it, as I knew sometime, but then I tried to put a rock border in and everything. Okay, the lot, we got the lot, we knew the owners of the lot, and we're maybe gonna do both of our lots. It was the Shermans, Noah and Pauline Sherman, or Lefty. He was a law associate with a friend of mine. Gonna build, that didn't work on out. They wanted us to get it because of his health reasons and all, and we have previous plans with his variances and what they had to do. Very similar to Ham's next door. They're gonna put a garage right next to Bob's garage down low. I think it was approved, and then a swing around the road coming through, not allowing the road to widen. Okay, anyway, what's happened, we've had the lot, and rather than developing it, developer, another development, we love Kensington. We have our daughter that lives in a house that could be opened up, that has 4 children. Our 2 youngest we went back far enough to Kensington, Hilltop, and then we have 4 grandchildren that have gone through. There's still one there, one last, and our daughter, he's finishing, he's going to middle school, so she's been raising her family, so we've had a whole family here. What we've had with the lot and where we're at is, what are we going to do? Our house is a little larger than we need, the current house, because 6 months before we moved into our current house, we lost one of our children. He passed away, so a little larger, and the kids have gone on. What we also have done, if you're aware of, why can't we convert our current house, the house up on the hill, that can be brought in? Our house was designed, and actually he interviewed Jonathan before he passed away, by John Troutman. You may have heard of him or not. Tremendous architect from the area, dear friend of ours. A protege of Don Hardison and Rich Komatsu. John Hardison brother, Red Oak, tremendous developer. So we've got a lot of architecture in the house. It would not be conducive, it would violate the house to try and change the existing house and do anything for handicap. We have friends, relatives that already have problems on handicap. So I don't know what we do. If it doesn't work out that the lot below makes it well for handicap and for us to grow what we're trying to do, and you guys can see the plans, then I suppose it'll have to go back to some Samoji plans and just get developed. But that's why we can't do it. Our current house is not capable of being violated, of going up, going through stairs and everything else. Plus, we still have a large family. And I think, any other comments? I can take questions. Danielle has been here since even before he got in Kensington. They asked her to be, and she's been secretary of the KCC for 40 years. And so we're involved in the community, and now we're at a stage do we either have to sell and leave, and you know, this lot gets another owner or something like that, or can we work? And we're trying to go with the community. Where I haven't talked to people here, there's been, like Jonathan said, 4 iterations looking through to try and get one that we thought best fit the street. There were earlier ones where the building was flip-flop with the garage over next to Pam's place, back and forth. All of them had major problems with the professionals we talked about, not the neighbors. And then Jonathan's work, and there's been just a lot of work for a period of time. So that's where we're at with even compromising the square footage. Jonathan had earlier square footages that were larger on the lot, as he mentioned. But anyway, any questions from myself or Danielle? And,
before we open it up to you, I just want to make sure that David and Dahlia don't have any questions.
I do not. Thank you so much.
Oh, we have. Oh.
She's another board
I think that the plans are pretty self-explanatory.
Right. At this time, then, I will open it up to the public, and let's try to keep, I'm going to time it, let's try to keep it to 2 minutes a person, just so we can, I can get home.
Just a comment, they've taken more than, we have 7 speakers.
Okay.
And at 2 point, that's 14 minutes, they've taken up to 20 minutes.
Well, like, let's just.
Well, try and make it.
Let's try to be,
2 minutes each.
Because we also didn't read everything, keep in mind, we didn't read everything that you guys put in place. He hasn't though, so,
And let's just try and assume that we might be talking again next month. So,
Yeah.
like.
Okay, yeah.
Yes, so can you clarify, what the square footage of the lot is total and then what the total coverage is?
Lot square footage?
Sure. And then
Since you say
building
it's
square-
incorrect in
and then
the.
building coverage,
Yeah, hold on. I think it's 7,000 lot area.
7,600.
Right on the survey here, it's 7,792.
Okay. Got it. Okay. You had a question?
Yeah, I'll speak it up. Is that okay?
Yeah.
Okay, first of all. Great. So,
Oh, sorry.
Please, start it.
so my name is Andreas Kuhlmann. My wife Angela Hasty Kuhlmann and I, we live at 25 Highgate Court for about 17 years. So first of all, I would like to thank you guys for doing this in this important way. I know this is a voluntary job, and we have seen it in the first case. It's sometimes very difficult, right? So appreciate really your patience on that. The second thing I would like to say, we really learned about this exactly 1 week ago. That was through neighborhood communication, and Bob got a letter from you, Mr. Albright. We did not hear about this before. We were in panic mode. We could not retain an attorney. We learned a lot of things about the.
If you can talk louder so they can all hear you.
Right. So we could not retain an attorney. We learned a lot of things, a lot of us, in 3 days about zoning rules, about regulations and so on. So what you see, the material we prepared was in a rush and to the best of our knowledge, including some of these pictures, to really illustrate what the impact of it is. I would like to state also for the record, right, we as a neighborhood, we fully acknowledge the right of any property owner to build a code compliant building there, right? We are happy to engage with you in some collaboration to find something that works. really appreciate you. But we believe that the proposal or the application, we really have to oppose. And the reason why, there's several reasons you will hear from us in detail, right? The first of all, that would be the most largest house on the small property, or the, relative to the property, the largest house in the entire Highgate Court. Number two, as we pointed out, it would require 4 variances to get to that size. Number three, it's a building that would go along the entire property line from left to right, be very, very different than any other building. Every other building has a front yard, has some nice view and so on. It would be a massive building, essentially, and right at the tightest curve of our court. And you will hear from the neighbors, this is a tremendous problem for the safety of our people. We have several, older people that need emergency services regularly. The fire trucks have already tremendous difficulties, not even thinking about a fire where we need to do evacuation. This is 15 feet, a very, very sharp curve. The last one we want to really mention, we're going to elaborate on this. This would require a very heavy construction. It's going to cost a lot of money, right? But this is a non-trivial construction. This is not just a house on top. This would be heavy-duty trucks, heavy-duty excavations, meaning that means that the curve would be blocked for hours at the minimum, if not days, for extended period of time. This is something we, as living on the upper court and lower, we just can't afford. We cannot have Chris, needing some emergency service suddenly and nobody gets through. The trucks for our service are already having difficulty right there. So this is something. I would also like to say something else, Mr. Palmer. And I'm relatively new, and I hear a lot of the history. And you mentioned, the soil erosion, right? What I'm hearing, we try to collaborate with you. I would really appreciate if you could do this better, because I don't think there was a lot of collaboration. The soil came down, it really shortened, the curve on this something. Let's find a restart of our relationship and get to something, that we can do more properly. So you hear from 7 more speakers. Actually, Atana had to leave. She was on Zoom.
Okay.
So we try to obey to the 2 minutes. We respect your time. We don't want to be here at 11 o'clock. We also respect your attitude. The best would be if you can work it out as a community, rather than come with something. Maybe here's a dispute there. Maybe it's a dispute there. I want to just show you some of the pictures that but it's a massive building, right, that you're planning to do. I think you would probably appreciate that, right? I mean, it's a non-trivial project.
What is your name?
Andreas Kuhlmann.
Okay. And were you at the meeting about the dirt coming down that I saw?
We were all involved in that.
Were you at the meeting that I showed up with the fire person?
No, I was not there. But,
Okay,
but we as a community, we talked about it. Right?
Let's, thank you. I
Yeah,
appreciate
thank
it. Let's move to.
Okay.
Brooks.
Thank you.
Okay, where can I stand where I'm not gonna block the people on Zoom?
Right next to, yeah, right,
That's perfect.
Okay,
Yeah.
so they wanna address, builders as well as the architects as well as everybody else here. I don't know if this is.
Maybe if you go behind the sign.
yeah, behind it.
Yeah.
That's perfect.
Okay.
There you go.
My name is Jeremy Stone. I live at 7 Highgate Court, which I fell in love with 10 years ago for the calm, rustic setting of mature trees and privacy. I love the secluded personality of the homes on Highgate Court. When you walk our street, you smell and see blooming vines, flowering bushes, lemon and pear trees, succulents, and a profuse, consistent love of nature and demonstrated landscape design through gardening. How to integrate a new home into the hillside? That is the challenge and a question. And how do you integrate a new home into a community of families? I work in the art world. I studied at Cooper Union, which is a school of architecture, art, and engineering. My career has been about aesthetics and design and finance. From my perspective, this proposed design is out of scale in height and bulk to the lot size. As drawn, it looks like the Starship Enterprise, a spaceship landing on our bucolic little street. A street that looks like a strand of spaghetti falling off a rack. It is narrow and totally there's nothing about our street that is easy to navigate by car as it exists. The house also suggests a cruise ship that is docked on our street for unloading passengers, towering over my neighbors, 43 feet above asphalt. This building would completely block light and privacy for Pamela Drake's bedroom, who lives at 19 Highgate Court. It would cast a huge shadow and loom over Marika and Laszlo Somagil's downhill home directly across the street in their front yard garden. This project requires more thought and a redesign. I recommend denial of this as submitted.
Thank you. 40 seconds to spare. Yeah, please.
Hello. I'm Vahis Satari, and my family, we have lived at 23 Highgate Court for the past 31 years. I'm here to express our opposition to this application. Specifically, I believe the 4 variances that are requested here, they don't meet the acceptance criteria, and also they undermine the safety and the character of our neighborhood. The first variance is for an 8-foot front setback. This is requested for a 2-car garage, but apparently consideration was not given to traffic flow. When we built our garage 20 years ago, engineering studies were done that they show a minimum 10-foot setback was needed for safe maneuvering the car and turning in a wider section of the road in front of our house. Certainly, at this point that in front of this lot that the road narrows, even a deeper setback is needed. Clearly, having an inadequate setback will cause a car that wants to go into the garage, entering or exiting garage, they have to go back and forth multiple times, and they will block the traffic during this. The second variance is for 8-foot retaining wall at entry stairs, where these are twice the permitted height. In Kensington, steep slopes with terraced short retaining walls are commonplace. The tall retaining walls in this project are not inevitable. They are directly driven by the choice to place the house at the closest possible spot to the front of the lot. The third one is an 11-foot cantilever deck. This is unlike any other house in the neighborhood. The application reference to similar decks in adjacent properties is not correct. The deck at number 19, Pamela's house, is a modest 5-foot deck that was built in 1970s. Certainly that cannot be used as a precedent for this new extravagant deck. The fourth optional variance is for front parking pad and a 10-foot retaining wall that other people will talk about this. Planning code gives 3 main criteria for variance acceptance. There should not be special privilege for the applicant. The special lot conditions that deprive the owner of rights that are enjoyed by others. And finally, substantially in compliance with the code. The multiple overlapping variances in this case, they don't meet any of these criteria. And together, they are unprecedented. So, respectfully, we are asking KMAC to recommend that these variances not be accepted.
Thank you.
Hi, I'm Yasha Hoffman, and me and Marissa live at 24 Highgate Court, cul-de-sac. Nice to meet you. So as you mentioned, I just wanted to talk about this pad in particular, which is 9 feet wide. What's that? Well, sure. I think
This is beautiful. But we could like turn it a little and bring it back.
okay. Sorry about that. Apologies. Okay, so we're talking about variance number 4, this button pad. 9 feet wide with a 10-foot wall directly behind it, and I believe the code says that with a wall next to it and a street on the other side, it must be wider than the 9-foot minimum. And there's just no way to fit a standard car with the doors open without blocking traffic this is the narrowest point on a blind curve, 15 feet. We've already had issues with emergency access. Chris lives next to us, and we have 6 families, including families with young kids. Maybe I think we should. There's a photo in that packet showing a Kensington fire engine that had to back all the way out after an emergency call because it had no room to turn around. So it barely works now to get emergency vehicles in and out. And a car parked there, even sticking out a foot or two, might make it impassable. And this is also a fire evacuation route, and for elders and kids, there's no other option for getting out. And for, if a car were to be parallel parked here in this 8-foot spot, that would be even worse, I think. And as Wahid mentioned, he found when they did a traffic study for his carport, they needed a 10. The county found a 10-foot minimum, and that was at a much wider part of the road. So there's no one other factor is just thinking about the necessary and important question of handicap accessibility. I believe that California, I could be wrong, but I think California law requires 13 feet minimum, or 16 for a van, and this pad is 9. So I am requesting that you make a recommendation to deny the variance 4, and so that would be the application that's submitted. And if it returns, I think what we would need to go forward would be a traffic study, getting the fire district to sign off, and just finding a parking solution that just doesn't block the road, the only way out and in for 6 families and emergency vehicles. Thanks.
Okay, good evening, board members, neighbors. My name is Robert Harrison. My wife Stephanie and I have lived in our home at 16 Highgate Court since 1974, 52 years. I know I am speaking for all of us when I say that we have a deep affection and attachment to our court, this neighborhood, and Kensington in general. We all know and share the reason we are here tonight. It should be stated outright that the structure proposed to be added to our court neighborhood will irrevocably change. In short, the proposed project is completely incompatible with all the other houses and properties on our court, homes which all share the same footprint, but this one will surely not. All the other houses are appropriately set back from the street, sensitively landscaped with vegetation, and present a non-obtrusive presence. In contrast, this structure as proposed will tower over, dominate, and literally overshadow several houses. This would be the largest house on the smallest lot, as is already pointed out. It would be unlike and incompatible with every other home on the court. All this is in addition to all of the other problems we're discussing here tonight. Since the overwhelming scale of the project cannot be realized from 2-dimensional drawings, we ask for a site profile story pole frame on the lot in order to make clear to all the impact on our small cul-de-sac, much loved neighborhood. Thank you from all of us for your attention and consideration, and we also recommend that this not be approved. Thank you.
Thank you.
Margaret, would you like to speak to that? Oh, no.
But you can if you want.
Shauna, not being here, you can speak. You could take her slot. Slot.
Anyone is entitled to speak.
It is one of the main problem is this narrow road that we have. This is the only way this property even a small obstruction can be fatal. Last week we had a medical emergency. The first aid came in a few minutes with a large vehicle to take my husband to the hospital. 2 more emergency vehicles came and waited until all the tests were made on my husband. Even a bicycle would have had a problem passing them on this narrow road. There is no room for building trucks blocking their way for many months. It could be fatal for more than one person on this narrow side road.
Thank you.
Chris, you're up. I'm bringing her.
You don't have to stand up if you don't want to.
Yeah.
Stacy,
Okay, we can.
She wants to
Okay.
Okay.
I don't have that special variance for this to go through. My name is Christine Ford. I live at 28 Highgate Court, the last house at the top of our steep street. I have lived there for 25 years. I am 90 years old. I haven't driven for several years because of medical issues, so on numerous occasions I've had to rely on medical assistance. I have frequently watched the tortuous turns that a fire engine has to make, going up but primarily downhill. Any vehicles parked in the roadway are major impediments to the passage of these vehicles. Having a 2-car garage and driveway so close to the bend in the road seems an unnecessary cause of problems. Desperate parkers often don't display a modicum of common sense or courtesy. Those of you who were living here at the time of the disastrous Berkeley-Oakland Hills fire in 1991 will remember the difficulties fire engines faced attempting to fight the fire because of the narrow and twisting car-clogged road. They just couldn't get through. I had friends who lost everything. It's a persistent, painful memory, and it could happen here because of the number of interfaces between that scenario and the one we potentially have now. Given the number of elderly residents on the street and the number of small children, making the passage of emergency vehicles as safe and expeditious as possible seems the prudent thing to do. Reducing any possible street congestion related to parking issues seems the most reasonable and effective action to take. I recommend against yes, I thank you, but I do recommend against this action you're proposing.
Is there anyone else?
So we have Chana Raja, she had to leave.
Okay.
She has a meeting. You would ask for someone else reading her statement?
That's fine.
Okay?
Yeah, absolutely.
Sure.
There's one last item.
Yes, and then you. Yeah, okay, great.
Sure, so I'm representing Archana, who lives next to us at 20 Highgate Court. She's a staff scientist at LBL. It has to be on site in person. She has 2 small children, tight morning schedules, no margin for error. And setting aside design questions, she wanted to focus on what construction would mean for the families in the upper court, the 6 of us above it. Every day, not to mention the ones who are right around it, every day for up to 2 years. So she points out that the 9-foot hillside cut, tile-driven foundations, retaining walls up to 10 feet, and the size of the multi-story structure, it makes for a big project. And all of this access, so I'm skeptical that it can be built on a 15-foot blind curve with an 8% grade without obstructing traffic for hours, if not days. And pile driving rigs, concrete trucks, excavators repeatedly occupying or and blocking the cul-de-sac. She points out that there's no alternate route during that time of construction, and if equipment blocks the road, upper court families would have nowhere to go. A blocked road on the wrong morning would mean for her missing a critical shift at the lab or a late school drop-off, but every household on the court will have a different story, some of which are more consequential and urgent, like something like health vision, God forbid, a fire. It's a private road, and we recently, before we moved in a year and a half ago, the residents paid out of pocket to resurface it, so construction damage would fall back on us to repair. And as far as Archana knows, no plan's been submitted for maintaining emergency access on heavy equipment days. And so she's requesting denial, but if it comes back, she wanted to request a construction management plan that would guarantee continuous emergency vehicle access, a damage bond payable to residents, not the county, pre-construction surveys of adjacent properties at the applicant's expense with vibration monitoring during the pile work, and controls on worker parking, waste hauling, daily work hours that would be appropriate to a cul-de-sac with elderly neighbors and young families. So she's asking that her preference is denial. She asked if it does move forward, these protections must be locked in now, not deferred to the building permit stage, or recommended, I guess. And she thanks you for your work.
I'll come over here. My name's Bob Treppa. I live at 9 Highgate Court, directly below this lot. My wife and I, back there, have been in our house 30 years. I'm the last speaker tonight for the neighborhood, and I'd like to recognize those neighbors in attendance that chose not to speak tonight, and also to thank them, just to allow this presentation to be short. Thank you all. I'm here just to provide a quick summary of what you've heard from Andreas, kind of the various application issues that are original to this. Jeremy talked about the 3-story building right on the pavement edge of a cul-de-sac, towering over the neighbors without any of the various items that make up our neighborhood. But he discussed the variances requested in the proposal. None of the 4 meets the legal test for approval. Joshua addressed the parking pad leading into the road, where it will continue to impinge access to and from the upper court for decades to come. Robert spoke about the incompatibility of the characteristics of the neighborhood in terms of footprint, lighting, setbacks, vegetation, and also privacy. Both Chris and Marika talked about the importance of medical access and evacuation access, and Arshana, although she was not here and her statement was read, warned about the major impacts of major construction equipment on a private, narrow cul-de-sac for many months. It's really a life and death issue. For the reasons stated, and especially this is the biggest house on the smallest lot, the neighborhood recommends denial of the proposal as submitted. And if it's not outright denied, what's missing, before you conclude your recommendation, should be the story poles that were mentioned, where we have a sense of really how large and overbearing this construction would be, and also the good construction management plan, all of the points that were read to you about fire and paramedic vehicles, emergency evacuation, the pavement damage bond, pre-construction surveys, vibration monitoring. Really, the worker parking, waste haul, daily hour controls appropriate to a small residential cul-de-sac. So in closing, we respectfully ask KMAC not to recommend this project to the county. So thank you. Do you have any questions for us?
Yes. Has it been commented on the tremendous amount of potential damage that it will do to our newly paved street?
Yes.
To have major equipment?
Up and down. That's why we need a damage bond.
Okay,
Right.
thank you.
And that, the contribution to the resurfacing of the road, was paid by all of us. Except the applicant.
Yes.
Why weren't we approached on that, Pam?
Many,
Because
many
you called
times
us for
I have all the records at home. I went back to 2013.
No, I said for the one you just paved it. I would have been glad to pay our share.
Oh, no.
I never heard anything about it. but
No.
you said-
I have all the information.
Let's focus just on this, on this project.
I even dropped something off at your house.
Let's focus on this project. So is there anyone else from the neighborhood who wants to talk? So normally this is when we would close to discuss amongst ourselves. The question for you, the other option, if you guys want to take a crack at sitting down with your neighbors, going through the plans in more detail, maybe taking a crack at a different design, trying to find a compromise. What you guys can do is ask for continuance, and we can revisit this. We're not very heavily booked, by the way, from month to month. Although with the tree thing now, who knows? But if you guys want to wait until you guys can talk to these guys in more detail, have more group meetings, we highly, highly encourage it. You can see these guys were very well organized. They wrote a very detailed and organized letter about what their challenges are with this current project. I'd encourage you guys to read through that. I encourage you guys to meet with them and see if you can find something where everyone is generally okay.
Got it. Well, we agree.
Okay.
And I want to say you guys are really well organized.
Yes.
And you did a great job. I know the challenges of the street. It's a tough street. It really is. I had to take my hat off to you guys. You got down to bonds, road damage, massing. You had some inconsistencies. You want a wider road, but then you don't want you want a wider road, but you don't want this. So there's some inconsistencies, but we can work that out. I mean, we don't have to build that.
That's not the road though, that's a parking space.
No, but it's not for them. It's not required by the county. We did that because they knew that road was narrow. But you guys nailed it. And we heard everything. You guys did a great job. Including the renderings here, this is pretty good.
That I'd like to see more. No, I think, a couple comments and then jump. Can I make a couple comments then along the plaza? Actually, we saw over at Smogy's, the fire truck a few months ago, and that was one of the reasons to talk to Jonathan, saying, hey, if the road's tight. When I met with the group of neighbors there, we ran a line of what the property line was, and then what was the open easement, and said that can be cleaned up. So besides doing what Jonathan wants for this type of project, the actual thing for the setback came saying, hey, that leaves a space even though it's on private property, and many of the walls if you go up above. So a lot of that was thought earlier on that maybe wasn't as well thought of widening up. It certainly would save Danielle and I a lot of money if we do not build that 2 foot, the two placing out front. Because that was, what?
A lot of money.
That's a lot of money, Jonathan said. So what do we do with the narrow road? I've talked to the neighbors, and so a retaining wall that high, if a variance doesn't come, then our lot dish comes down. The deck above is only because of it being lifted up, and Jonathan talked to me.
We can walk through.
Walk through.
But what I wanna know, is how can I interact with your group?
I think Bob and I volunteer to be the contact people. We would include
I would come with my sketch paper, clean slate. I'll walk you through every scenario we came up with before. There's 4. You can sort of see the evolution of the species here, because it is an evolution. Every point you guys have brought up, we looked at and we made some sort of judgment. But obviously, we need a lot more work. So
why don't we?
Can I say one thing?
Sure.
First of all, I appreciate, if you have an effort to find a solution that works for everybody, right? We have a lot of concerns, and I beg you to take those seriously, because we will fight it otherwise. You see a bunch here.
no,
that,
I've been part of groups just like this. You're not mentioning the lawyers, but I know what you mean.
If we can find a solution that works well. The second thing I would like to mention, this is not yet, I think there's a lot of trust to be built. I mean, you heard a little bit some of the emotions and so on. I'm a younger person on the court. Trust is a foundation here to essentially move forward. So I want to just mention this to everybody. It's very, very important. We can promise each other and so on, and we don't have all the promises. This, I think we feel very comfortable, about what we think is important. I think we will compromise if needed. We would love to come back to you with a total signed off from everybody. but I want to stress it. It's important to build the trust.
Well, I apologize if they didn't receive the letter that was sent out.
But we've got time now where we go. What I want to mention, we trust Jonathan tremendously. My friend John Troutman, who had been in Hardison's group, had interviewed, talked to him, and John's gone now and all. We are gone, as you know, as Pam would know. We're Danielle and I, with 11 grandchildren in 3 states, and at this stage of our life. So we will trust going through Jonathan on it, and hopefully we can see where we can stay an elevator and work on the property. The property can be built without variances, but will it be better to do this for the community or just drop this? So I don't know, but Jonathan can work and show you many of the things you mentioned. We brought up to Jonathan, he brought back. Maybe didn't resolve them the way the neighbor thought. You guys thought we should, but we'll work with options. If we can make it work for ourselves, fine. If not,
again, I want to repeat the trust. This was filed on April 3rd. We heard about it a week ago, on April 22nd.
And they pulled it all
This is
together.
like, we were in panic mode.
what?
So were we.
Yeah.
So,
We were told all the time. We didn't know about this meeting for a while before. We thought it'd be May or whatever, but it opened up quicker.
And the planner just was not communicating. We wanted to talk to the
April
planner.
2nd could have been the time to.
Let me stop here so we can.
Sorry about that.
We're not advancing things right now. So the next steps are you guys are gonna connect. You do not have to do next month. You can pick a point to when
We'll
you
let
guys.
you know.
Yeah.
You guys
It's
are ready.
gonna-
It's the
gonna
last.
take a bit.
It's the last Wednesday of the month. You reach out to Joanna and do that. And with that, I'm gonna close comments.
May I make a comment?
Just as you know, I haven't eaten anything in a long time, and I'm getting a little hangry. So it's gonna be fast, cool.
Yeah, it's gonna be fast.
Okay.
I just wanted to thank Mr. Power and Ms. Power for considering our suggestions, and we are open to the discussions with you. I wanted to emphasize that we are not against development, but majority of our issues is about the scale. If you are willing to consider bringing the scale down to something that's compatible with the neighborhood, doesn't overshadow, doesn't tower over, you will find very cooperative group here.
It might be good for Jonathan to meet in your neighborhood with you, I've done it. But, and get the numbers switched, because Danielle and I are gonna be, basically, we're leaving next Wednesday, so
Great.
I don't wanna cut that, but just get the
Well,
information
look
and
on-
work with you.
There's so much Kensington history in this room. I've been here since 2014, and I'm in awe how you guys all got together.
Isn't it amazing?
And put together an amazing presentation. This is very civil, very organized, very professional. So thank you so much for what you guys did.
California has
Thank you guys.
lots of hills.
It does. It does. And that's good and bad.
Okay.
But I'm looking for.
I'd like to make a motion for a continuance for CDP 26-03008.
Can I get a second?
Second.
All in favor?
Aye.
Dahlia.
And that's May 26th?
Dahlia in favor?
Yes, yes, sorry. I'm in.
Opposed? Hearing none, the motion passes.
That was the number of
Do we want to
docket number.
motion to adjourn?
I'd like to make a motion to adjourn.
Second.
All right.
Thank you.
Motion adjourned.
Thanks, everybody.
Thank you guys all so much. We really appreciate it. You guys were awesome. I stopped even doing the timer.